In today's Supreme Court news, we turn our attention to a woman who owned a house and the government wanted to take the house to pay an unpaid debt. Well, that sounds like that might be fine. She owes the government money. Here is a thing that is worth money. Let's take the thing to pay the money. That sounds fine. Where things get a little bit more tricky is they wanted to keep all the money because the house was worth more than the debt. So they owed some money and the government said, we'll sell it. And it turned out to be more than that. And they're like, we'll just keep it all. What? That sounds a little bit weird, but some states are doing that. So that is the case. Can the government keep all the monies? If you owe them $10,000 and the thing is worth $100,000, can they just keep the $90,000 extra because they want to? Is that a thing? Let's get started with this. Miss Taylor owed a condominium in Hennepin County, Minnesota, that accumulated about $15,000 in unpaid real estate taxes, along with interest and penalties. The county seized the condo and sold it for $40,000, keeping the excess $25,000. She owes $15,000 in the real estate tax. The real estate tax is, of course, associated with the property. Let's take the property to pay the tax. She owes us $15,000. We sold the condo for $40,000. What do we do with the extra $25,000? We like money. Let's keep the money. Yay, money. Wait, that doesn't seem quite right. So the woman over here files suit alleging that they've unconstitutionally retained the excess value of the home above the debt in violation of the takings clause. Okay, you took my property. You took property I didn't owe you. That seems like that's illegal. The district court dismissed the suit for failure to state a claim. Yeah, the government gets to keep your money. Why are you sad? The Eighth Circuit also affirmed the government gets to keep your money. Why are you sad? So that was the ruling below. All right, so what is the right decision now? The Supreme Court holds that the woman plausibly alleges that Hennepin County's retention of the excess value violates the takings clause. I would tend to think so. Yeah. Her claim that the county illegally appropriated the $25,000 surplus constitutes a classic pocketbook injury sufficient to give her standing. Yeah, she has standing. They took her money. In fact, she is standing over the entire thing. They took her house. The entire thing is subject to due process. Of course she is standing, to raise the issue. You're not allowed to do that. Of course she is standing. What? Yeah. If there are debts on the home, Tyler still plausibly alleges financial harm to keep the $25,000. Yeah. I mean, you would think. Tyler has stated the claim under takings clause, which provides private property shall not be taken for public use. Whatever remaining value from a tax sale is properly protected under the taking clause depends on state law, traditional property law principles, historical practice, and court precedent. Though state law is an important source of property rights, it cannot be the only one, because otherwise a state could sidestep the takings clause by disavowing the property interest in assets. So yes, property law is typically defined by states. This is not controversial. Homes, of course, in particular, are defined by states. The land, of course, in particular, is typically defined by states. This is typically a matter of state law, what property is and how you own it. Now, the state coming along and suddenly saying, hey, wait a second, this isn't property anymore. So we didn't take property because it's not property, because we say it's not property. Obviously, that could be a real problem, right? If the state gets the right to define what property is and it wants this thing, one of the things the state might do is just simply say, this isn't property, so we didn't take property. So obviously, no, we're not that dumb. History and precedent dictate that while the county has the power to sell the home to recover the debt, it couldn't use the debt to confiscate more property than was due. Doing so affected a classic taking in which the government directly appropriates private property for its own use. Yes, that makes logical sense. She has a debt on the property. It is a tax debt on the property. We seize the property to pay the debt. We have paid the debt. Incidentally, if the property had not been sufficient to pay the debt, the county would want more money. So if the property only sold for $10,000, then they'd still say, hey, you owe us $5,000 more, right? It wouldn't typically extinguish the debt. So if they say, okay, the property only sells for $10,000, you still owe us $5,000. If the property sells for $40,000, we get to keep the $25,000. How does that make any sense? It doesn't. The principle that a government may not take more from a taxpayer than they owe is rooted in English law and can be traced back to the Magna Carta. From the founding, the government of the United States could seize and sell only so much of land as being necessary to satisfy the tax. Yeah, I mean, that makes logical sense. The government has the right to tax. The federal government has the right to tax. The state government has the right to tax. Taxes and death are the only things certain in this world. So can government tax the land? Sure, they often do. What happens if you don't pay the debt? We'll take your land. Okay. I mean, fine, but only take it as much as you owe. That sounds better. 10 states adopted similar statutes around that time, and the consensus the government could not take more property than was owed was held through ratification of the 14th Amendment. Yeah. I mean, this is pretty ancient common law. This goes as far back as you like. So we just like money for the sake of money has been illegal for a very long time. Today, most states and the federal government require excess value to be returned to the taxpayer, which is incidentally true also, by the way, of private debt. That is secured debt. For example, a car would be the most common way you would have secured debt, or for that matter, a home with a mortgage. The same thing would be true. So you own a car. You have gotten a loan for the car. You own a house. You have gotten a mortgage for the house. What happens if you stop paying the loan on the car? What happens if you stop paying the mortgage on the house? Well, the bank is going to take your car or your house to satisfy the debt. What happens then? Well, according to the law, they have to sell the house in a commercially reasonable way, which typically means an auction. That's how you do it, typically at a public auction. It doesn't have to be a public auction, but that's the way you typically do it, right? You have a forfeiture sale, you publish it in the newspaper, you say anyone who wants to bid on this house, typically show up at the house itself, is typically where these things are done. Show up at this date, at this time, and bid on the house. Great. It's a car. We put it up in a car auction. They happen all the time. Great. We sell it in a commercially reasonable way. What happens if the house or car sells for less than the debt? You still owe us money. What happens if the house or car sells for more than the debt? You have to get the money back. Okay? It's in the UCC, damn it. All right? We have to give you the money back because it's not ours. All right? We sold the thing. There's a windfall. Whose windfall? Your windfall. It's your money, damn it. So what's true of a private party is still true of the government, amazingly enough. The court's precedent have long recognized the principle that taxpayers entitled to surplus. The relevant cases that we've discussed in our precedent does not change that. The ordinance challenge in the relevant cases did not absolutely prejudice an owner from obtaining a surplus, but instead simply defined the process through which the owner could claim the surplus. So how do you go about claiming the surplus? How do you go about asking for the government to give your money back? Maybe there's a process to do that. It's due process. Okay, that's fine. Give them due process. That's cool. So you have a particular process to ask so that they get the money back. That sounds fine. That's cool. Minnesota's scheme in comparison, not so much with due process or any process of any kind. So our precedent says, yes, state, you can define due process. And you can have them go through a particular method of doing that. But Minnesota's here, how about like no method? How about we just get to keep the money? Significantly, Minnesota law itself recognizes in many other contexts the surplus. For example, the car and house in the mortgage and car loan examples we've been talking about. If a bank forecloses on mortgage, state law entitles surplus. Yep. And collecting past due taxes, Minnesota protects taxpayers' right to surplus. Minnesota may not extinguish the interest it recognizes everywhere else to avoid paying just compensation. Yeah, if a private party were to do this, you'd get the surplus. So why are we different? Because we're the state. The court rejects the county's argument that the Tyler over here has no property interest in the surplus. This should be good. She doesn't have a property interest in the surplus. Why? Let's figure that out. Why? Because she constructively abandoned her home by failing to pay taxes. Wow, that's nice. She abandoned her home by failing to pay the taxes on the home. Wow, that's some bullshit. How deep do we have to try to find that argument? Abandonment requires a surrender or relinquishment of all rights of a property. Yeah. So if you abandon property, any property, by the way, if you abandon any property, then yeah, it's abandoned. So it's not yours anymore because you gave it up. If you throw a piece of paper in the trash, You've abandoned it. It's not your piece of paper anymore. If you leave your home because you don't care about it anymore, then it's abandoned property. Can the government take that? Sure, because you don't want it. It's not your property anymore. But it requires you to, actually do that. It requires you to throw away the piece of paper in the trash. It requires you to do the equivalent of that for a house. I didn't pay property taxes, ain't it, Chief? Minnesota's forfeiture law is not concerned about the use of property, only the failure to pay taxes. The county cannot frame that failure as abandonment of the entire property. Roberts files an opinion for a unanimous Supreme Court because, this is pretty easy and this is pretty dumb. So yes, states everywhere cannot just seize your property and keep all the excess because they feel like it. No. Thus, that brings us to the end of the case in which the United States Supreme Court kind of states the obvious. If you owe money to somebody, anybody, and it's a secured debt, such as a car loan is secured to the car, such as a mortgage is secured to the house, such as often equipment in a commercial context is secured by a loan, and the loan is secured to the commercial thing, the industrial equipment. If you have a secured debt of any kind and you default on the debt, one of the remedies is the people who gave you the loan get to take the thing. That's what's in the nature of it being secured. It's a secured debt. So they get to take the thing to pay the debt. So taxes are like this in this respect, okay? It's a secured debt against the house. Okay, fine. We'd like to take the asset to pay our debt. Fine, no problem. Hey, wait, there's extra money at the end. We'd like to keep the money. No, that doesn't work in a private context. It doesn't work in a state context. You own a car, you own a house, you own some industrial processing equipment somewhere. It turns out that the equipment is worth more than the debt. Turns out the car is worth more than debt. Turns out the home's paid more than debt. You get a check. But the government said, we get to keep it because we like money. And no, this is very, very illegal. So the Supreme Court stating the obvious this morning, and that brings us to the end of discussion of this case.